All right, we are on the record in State v. Kohberger, CR 0124-31665. Present today by video is the defendant in custody with counsel, Ms. Taylor, Ms. Barlow, and Ms. Massoth. State is represented by Mr. Thompson, Mr. Hurwitz, and Ms. Jennings. On behalf of the media petitioners, we have Ms. Olson and Mr. Pedersen. Today's hearing is to discuss the media's request to terminate the non-dissemination order. The state filed a response indicating it was no longer objecting to that, and the defense did file an objection indicating that they do have a continued objection to lifting the non-dissemination order. I've read the briefs that have been provided by the parties, and I'm going to attempt to shortcut things here a little bit by asking whether the defense, who is the objecting party, has anything additional to add beyond what it had in its briefing before. I don't know that I need to hear from, frankly, the petitioner. I think the briefing was adequate, so let me just start with Ms. Taylor to see if there's anything else she wants to add.
Your Honor, there is not, but if there's further argument, Ms. Barlow will be making that argument on behalf of the defense.
All right. And to be fair, Ms. Olson, was there anything you felt was important to add that was not contained within your briefing?
Your Honor, we would just briefly say in response to the defendant's brief, we certainly understand the expressed concern about the media coverage of their client. We don't think continuing the non-dissemination order helps that at all. It simply continues to limit the ability of the members of the press to reach out to the people who know the most about the case. It doesn't obligate them to say anything. We also understand that they expressed that there was a due process right related to the sentencing. I read the case that they submitted. I think that there is obviously a due process right at sentencing, but I don't think that case is really it doesn't provide any guidance to the court here, because that was about information provided to the court, and given the very limited scope, and we understand it's very important, but given the very limited scope of what's to be decided at the sentencing, we don't think the arguments that Mr. Kohberger made should outweigh at this stage the First Amendment rights of our clients. Thank you, Your Honor.
Thank you. All right, in light of that response by the media outlets or interested outlets, Ms. Barlow, do you want to add anything?
I would only say, Your Honor, as this court is well aware, the publicity in this case is so extensive and emotions are already so high that adding fuel to the fire of media interviews or a rush to interview people as they leave the courthouse or enter the courthouse would only increase the concerns that the defense has. And even though the plea has a specific sentence attached to it, as this court is well aware, things happen in plea hearings and, sentencing hearings. And to minimize the possibility of that, we request that this order stay in place.
All right, thank you. All right, as the court has considered the petition, frankly, the court was prepared at the time the plea was entered to lift the non-dissemination order in order to give the parties time to evaluate that and to ensure I wasn't missing anything. When both sides objected, I agreed to continue the non-dissemination order. I also indicated that I would have the potential to look at that again before sentencing, because frankly, I anticipated the motion from somebody, in this case, the Ms. Olson and her clients, was likely to be coming. At this point, I do not believe the purpose of the non-dissemination order, the primary purpose, which is to ensure that we can seat a impartial jury, is any longer at play. The concerns identified by the defendant, while certainly not to minimize those. They are concerns, and they are significant concerns. I do not think, however, the non-dissemination order and the right of the public to information is outweighed or outweighs those rights, I should say. And frankly, I don't think that lifting the non-dissemination order will meaningfully impact those concerns. I mean, the media frenzy, as it has been described, will continue regardless. It is a little bit like water will find low ground. In this case, the media is going to write about something regardless about this case. The lifting the non-dissemination order does not require the council or others who were previously bound by it to speak. And the state has indicated they don't intend to until after the sentencing. And certainly I would hope that the media interests would respect those positions and give people the space that they need and request. In terms of, for example, the defendant's family and others coming and going at the sentencing, we intend to have, as we did before, appropriate security measures in place to ensure that they, as well as the victims, are allowed to get in and out unscathed by the media, if that's what they wish to do, or if they wish to speak to the media, they can do that as well. At this point, I just don't think that I can justify the continuation of the non-dissemination order. I think the rights of the public to information in this case is paramount, given the fact that a plea has been entered in this case, and so I'm going to lift the non-dissemination order. But I want to point out what that means and what it doesn't mean. So obviously nobody's required to speak to the media, first of all. Second of all, I want to be clear that the court's prior preservation order to the parties is not lifted and continues to stay in place. And so it's important to understand that those obligations still exist. And then the other thing I want to point out is that by lifting the non-dissemination order, that does not convert sealed documents to unsealed documents. Documents previously sealed by the court are still sealed. Now, I see the media also filed a petition to be heard to unseal everything. I'm denying that outright. The request to intervene, because I think it's premature at this point. So the court will its intent is to, after sentencing, begin the process of reviewing all the sealed material in this case to determine what should be unsealed and what should not be unsealed. That process will include an opportunity for counsel to register any objections to unsealing documents, specific documents, and request to redact certain sealed documents before they are unsealed, or unseal them in a redacted form. I intend to do that in groupings of documents at a time. As I sit here now, my thought is I'm going to start from newest to oldest, because those are the ones that I have the most working knowledge of as to the reason for the sealing of the documents, as well as the content of those documents. And so I think I can get through those more quickly. As we move backward in time, it's going to take further, more extensive review by the court to figure out, to obviously review the content of those documents, listen to those hearings, et cetera, and determine why they were sealed and whether that rationale still is necessary, or that rationale still requires the documents to maintain that sealed status. And so before everybody gets out their pen and paper and sends in public records requests, understand those will be denied for sealed records until they are unsealed. And that process is going to take time. And I'm not talking days. I'm probably not talking weeks for that to be accomplished. So I hope people understand patience will be required to get through that, as I'm going to have to review those myself to make those decisions. Now, we may be able to speed things up if neither party objects to groupings of documents or specific documents being unsealed. But it's important to review those because those documents may include information that pursuant to Rule 32 are not to be made public, including birth dates, social securities, information about minors and victims, and information that would be essentially inappropriate to unseal, including protection of individuals from undue harassment, et cetera. And so that's just going to take time. In addition, I'm unlikely to unseal much until after sentencing and after the appeals period has run. Now, I recognize the plea agreement includes a waiver of the right to appeal, but as the parties probably know, the U.S. Supreme Court in Garza versus Idaho has indicated the fact that a defendant waives the right to appeal doesn't mean they don't have the right to appeal. And so it may affect the outcome of that appeal, and it may affect the underlying case and the plea agreement. But nonetheless, the right to appeal does not go away because of the waiver. And so I think it's important for that time period to also play itself out to see that it goes the way that I think people intend and expect it to. And so I will be entering an order in the next week or so outlining the process for the review of the sealed records. And counsel will need to maintain a presence in the case in order to review those materials as they are proposed to be unsealed by the court. Because the timeline that I will likely give you will not be, I suspect, extensive as for each group of records. So I might give you 14 days, for example, to provide a response as to a group of, a dozen or a couple dozen records at a time. So just sort of heads up and fair play with respect to that. Any questions by the parties about the ruling today?
Not from the state, Your Honor. Thank you.
No questions from the defense. Thank you.
So Olson, do you have any questions?
And I don't, Your Honor. I wasn't certain if I was included within the parties. I would just say I think that the court's proposed manner of moving forward on the sealed records will likely largely address our interests, and we appreciate the court setting that out in this hearing today.
Yeah. If certain records after review maintain their sealed status, it would be at that point that I would entertain requests for me to consider that more formally and to have a voice in that. But I think until I've gone through that process, it's premature, which is why I don't intend to take up your motion, your more recent filed motion at this time. So,
Thank you, Your Honor. We appreciate that.
all right. And with that, then we are adjourned. Thank you. I'll see you next week.
Thank you, Your Honor.